You put E, okay.
For A, the U.S. v. Nixon case covers the criminal subpoena case because the president is not immune from multiple processing. B is the Clinton case, and also C is the Clinton case.
No. Stacy, what do you think here?
I reluctantly put B.
You put B. Okay.
Well, I wasn't sure if you meant like while discharging his duties, or I guess it is while. So I put B.
Okay. Why'd you put B? Explain, what case is that?
The Fitzgerald case.
That's correct. All right, so the answer is B. All right. Let me explain why. Let's see what you guys did. Ooh, okay, not bad. About half of you. The rest of you fluttered here. Okay. So let's walk through this, right? There are 3 cases today that we've studied. And all these cases focus on the president's immunities. But different kind of immunities. Okay? The first case we have, U.S. v. Nixon, focuses on immunities from a subpoena in a criminal case. Now, it's not the president's criminal case, right? This isn't about whether the president can be brought up in criminal charges. It's about whether someone else's criminal case could implicate the president. And the court held that there's no such absolute immunity. So this one is false. A is false. B. This is Nixon versus Fitzgerald. I put them in the same order you read them in. So it should have been really obvious, right? Can the former president, Nixon was out of office, be sued for actions that were taken according to his duties when he was president? Right? Court said no. There the privilege was absolute, which means it cannot be pierced. It cannot be broken. Then we have the third one. This is Clinton versus Jones. Right? Does the president have immunity from suit while he's in office? Even if the conduct occurred before he was elected. The court said here that there's no absolute immunity. Right? So, false, true, false. Everyone get that much? Yes, ma'am.
So what is the subpoena then?
Well, if there's a word you don't know, you should look it up. Right?
I did.
What does it say?
It says orders the person to testify.
Okay. A subpoena can be various things. In this case, it was subpoena ducis tecum, right? Which was the phrase used in the case. I think the book actually defines what it is in the brackets. Okay? Subpoena ducis tecum, right? That was the issue in Nixon. Subpoena ducis tecum is a production of documents, right? Is the production of documents. And that was what was issued in U.S. v. Nixon. Okay? A subpoena can make you testify in court. In fact, the court doesn't quite answer this question, whether the president will be forced to testify in court. Okay? All right. So everyone okay with this question, this following question to start off? All right. Let's start with U.S. v. Nixon. Okay? Let's start with U.S. v. Nixon. We already discussed this case indirectly when we did Morrison versus Olson. We already talked about this case. Michaela, you want to give us the facts, please, in U.S. v. Nixon?
A Senate committee was set up to investigate a break-in at the Democratic headquarters of the White House.
Uh-huh.
And so President Nixon appointed a special prosecutor to investigate whether the White House was involved in the break-in.
Okay, good. Then what happened?
And then the special prosecutor issued a subpoena to President Nixon, who was an unindicted code.
What was he seeking with the subpoena? The subpoena ducis tecum. What was he seeking?
He wanted the documents of
Be specific. What kind of documents did he want?
transcript of.
Not just the transcripts. What did he want?
He wanted the actual audio.
Very good, yeah. So here was the deal. President Nixon had a recording system in the White House. He wasn't the first president to do so, but he had one. And it was automatic. That is, whenever it detected voice, it would start rolling the tapes. He was paranoid beyond anything, and he was a fascinating historical figure. But he recorded all these various conversations in the Oval Office. And some of these conversations implicated the Watergate break-in, where he was aware of it, he was aware of the cover-up, and he was aware of maybe telling people not to tell the truth about it. The exact specifics aren't so much important. What is important for your purposes is there was several indictments. The footnote lists the various people who were indicted. There were several people in Richard Nixon's orbit who were charged with crime concerning the Watergate break-in. Nixon himself was not indicted. He was what's called an unindicted co-conspirator. Do you know what that is? An unindicted Yeah, Brian?
Somebody that's listed in the indictment but isn't formally charged.
Right, very good. It's someone who's basically involved in this conspiracy and this crime, but charges were not brought against him. Why? There's a very tough question. Can the president even be indicted? I gave you a little reading on this after the cases. I'm not going to give you an answer because I don't have one for you. There's no clear answer on this. My tentative answer is he can't be indicted, but I don't pretend to have the final word on this. So rather than indicting the president, they made him an unindicted co-conspirator. And they said, we want you to deliver these tapes through the subpoena, right? Now, Regina, why was it important for this criminal trial to have a copy of these recordings rather than just like a transcript that was edited down?
Well, in the transcript,
Okay, very good. Now, again, whose fair trial are we talking here? Is this Nixon's fair trial?
no.
No, it's not.
Oh, the other.
Exactly. Very good, Regina. This is the point that most people miss about the Nixon case, right? The reason why the court wanted the documents was not to try and take down Richard Nixon as president, although it had that effect, right? The reason why these documents were needed was to ensure a fair trial for Nixon's accomplices, right? That is, there may have been something in the recordings that exonerated the other conspirators. Or maybe it made them more guilty. We don't know, right? But to the extent that Richard Nixon was ordering them to break the law, probably what happened, that minimizes their culpability. Right? It doesn't eliminate it, but it might minimize it and give them other opportunities to maybe testify against the president. Again, no one knew what would have happened at that point, right? There were impeachment proceedings beginning, but no one knew he would ever step down. It was unknown. So the basis of this entire case, again, was not to take down the presidency, although I'm sure they had that in the back of their minds, right? The basis of this case was to give a fair trial to the other 7 indicted conspirators. Right, so the question is this: can the president's immunity defeat this subpoena, right? Does the president have an absolute immunity when there's a subpoena in a criminal case? The way I phrase it here is pretty close to the holding of the case, right? Does this immunity exist? Right? Now, JC, where would this idea of an immunity even come from? Is this anything in the Constitution? Is there anything in the Constitution that says the president has an immunity? I mean, I read this opinion a bunch of times. Where does this idea of immunity come from?
As far as the actual Constitution, they link that back to the separation of powers.
Yeah. Is there a clause of the Constitution that says the president's immune from subpoenas? Is there anything the court has to go on here from text of the Constitution?
No, the
No.
President's Counsel tries to urge that they need the secrecy and the president's secret information pertaining to Watergate shouldn't be divulged.
Okay. Right. He's right. This opinion, the Nixon Fitzgerald case and the Clinton v. Jones case, there's not much text going on here, right? to the extent that this immunity exists from civil lawsuits, I'm sorry, from a subpoena, it's based on the, Jason, you said separation of powers, this sort of general nebulous notion, right? Danny, let's go back up top, right? What are the general arguments of why the president should not be subject to a subpoena for someone else's criminal trial, right? What are the general reasons why?
Well, generally speaking, you would have, so you have correspondences with other branches of the government, you have correspondences with, like foreign entities, things of that nature. So in general, there is a shroud of secrecy that the president can fall back on. That's the idea behind it. And that is not, it's not universally qualified.
Yeah.
So if there is a reason behind it, so any type of general reason that can be given that's plausible, then he can invoke this and he can use his.
So what Denny's saying is there might not be an absolute privilege, but there might be a case-by-case privilege. Is that what you're getting at?
Yeah, basically.
Okay. So Denny makes a good point that very often the chief executive has classified information in his possession, right? And were this information released to the general public, it would make us less safe. The bad guys would know what we're doing. It'd be a bad idea. So Nixon says this privilege is absolute, right? It shouldn't be up to the court to decide case by case, just make it a blanket privilege. Denny, does the court accept the blanket privilege?
No, you can't have a, like, the court talks about like legitimate needs.
What? Okay, I'll go into Warren in a minute, but what does it mean, legitimate needs? You raised a very good word.
Well, I guess it's within his capacity.
Who decides if the need's legitimate or not?
I'm not sure.
Oh, you know the answer. Who gets to decide if the president's claim is legitimate or not?
Probably the court.
Bingo, courts, right? So what the court's saying here is the president doesn't get to decide whether to withhold it. We, the judges, do, right? If the president wants to make a claim for a privilege to be immune from the subpoena, make the claim. It can't be absolute. Someone got, I mean, that's a pretty significant holding. I think this was unanimous too, saying that the courts get to decide whether there's a valid basis for a claim. Everyone get that? That's the first reason is, right, security. The president can't just give a blanket privilege, not make the case. Now, Warren, let me give you another question. It's a bad example, but generally when people are giving advice, right, and they want to be very straightforward and honest about their advice, do they want to be recorded?
Are you recording? You're recording this right now.
I'm recognizing the irony, right? But as a general matter, putting aside class, right, if you were like giving a client advice, right, one-on-one, would you want your conversation to be recorded?
I would, unlike you, I would not choose to record myself.
Yeah, that's a good point, right? Why? You're not wrong.
Because if, you know, I have a, this may not apply to you, but I have a tendency to misspeak and maybe
We all do. Yep.
and maybe not say something that's absolutely correct.
Right. So if let's just say you're advising the president, right? You're a White House lawyer, and you know that one day your communication might be dragged into court. Do you think you'll give perfectly honest advice and candid advice? Do you think you're going to give candid advice if one day that conversation may be dragged into court?
I would try to give candid advice, but I'd probably give less advice because I'd be
There you go.
I'll get back to you on that.
Yeah, I'll get back to you on that. Exactly, right? So what the court also addresses is Nixon's other claim. This will chill the advice that White House lawyers will give to the president. If they know that their communications are not privileged, that one day their communications may be dragged into court, they may do it warranted. You know what? I'll get back to you. Maybe give more neutral advice, but not honest advice, right? When you know what you're giving advice is going to be held against you, you won't be as candid. That's why we have an attorney-client privilege, right? You study this all in CivPro, right? I think, right? Or you'll do an evidence if not. We have an attorney-client privilege that your communications between a lawyer and a client are not divulged, so you can be honest. Because right, imagine this, right? What if, what the advice is, Mr. President, you're probably breaking the law here, but we think we can defend you. You'll have that conversation one day. Yep, you broke the law, but I think we have a good defense. The warrant wasn't valid. Or yeah, you know what, you really committed that crime, but I think we can get you off because the police didn't conduct the search in a proper fashion. I mean, that evidence is damning. Look, his lawyer said he did it. But to have a good defense, you need to be candid with your client about what the odds are against him. He says, you know what, you did it. You really should plead guilty, right? You're guilty. Can you imagine if that conversation came out in court? It'd be devastating. But again, here the court says it's not absolute. There might be a case-by-case need where a private communication stays private, but it's not absolute. And that's the most important word in this case. Nixon offered that this was an absolute privilege, that there's no basis under which he can be compelled to give these recordings over. And the court rejected this claim. They say, absent a need of military, diplomatic, or national security secrets, we can't accept this confidentiality claim. Why? Because the other conspirators have a right to the evidence in their case, and that's the important point. Right? The ends of criminal justice will be defeated if we had this privilege. Yes, Laura?
So if the court's reasoning is that the president doesn't have absolute immunity because the defendants, have the right for a fair trial, can the president practice its pardon power? Or would that be kind of like he's pardoning himself?
Oh, you read the other reading, right? On the pardon power.
Yeah. Well, I was just trying to put it together because I know the president has immunity, but...
Well, let me put it this way. So, for the president to issue a pardon is a very significant political act, right? It looks really dirty when the president pardons people in his circle who are accused of crimes. There's a political cost there. But I'm going to put the politics aside and just look at the constitutional issue. If the president wants to stop this conspiracy charge against his other friends, he could pardon them all. He never did it. So the question is this: if the president can just end this entire charade by pardoning his conspirators, right? Why can't he do the same thing by just not giving them the documents, right? Why should he be compelled to participate in something which he has the power to end? The more fundamental question is this: if the president is the head of the executive branch, how could someone be prosecuted against his wishes? Right? That's the tougher question. If the president is the head of the executive branch, why couldn't he put a stop to any prosecution? Says, I don't want you prosecuting these guys, let it go. We don't even need a pardon. In other words, how can a special counsel demand a document from his boss? Right? How could Cox demand the recordings from the person who's above him? Right? You will all be lawyers one day. You'll all be associates in law firms, God willing, right? Can you make a demand of your senior partner? Hey, I think you should give me this document. No. It's the other way around. He or she will tell you what to do. Right? That's 101. When you're a summer associate, don't start making demands of senior partners. But here, you have a special counsel, whatever that is, making a demand of the President of the United States. Can that even happen? Now, the court, we know, upheld the special counsel statute in Martha v. Olson, about 10 or 15 years later. So we know that in hindsight. So Nixon didn't try to... Well, we know Nixon tried firing the special counsel, in part because of this, right? This is what precipitated the Saturday Night Massacre, because he demanded these documents. But once the new special counsel was appointed, Nixon was toast, right? He had to hand him over. But I want to just engage your question for a minute. If the president has the power to pardon these conspirators, the president has the power to stop the investigation, how come he has to comply with the subpoena?
Especially since that's the court's reasoning.
Nixon could shut down the entire prosecution if he wanted to. All right. Let me take this point a little bit aside. This moves more to the present, but the notion of the executive branch, we think of an executive, a unitary, one executive, but he can't do it all by himself. He has attorney generals and deputy attorney generals, associate attorney generals, etc. can the president stop a criminal investigation to himself? Or to ask the question differently, how can an investigation to the president exist unless the president consents to it? With the independent counsel statute in Morrison, it could. Under the current regime, it's a lot harder for that to exist. Brian? Was that better or worse?
The question was, is the president above the law?
Oh, we'll get there. We'll get there.
And I think this, the question that goes to that, and the idea is that you're essentially undermining the entire process of the criminal justice system if you don't allow the president to be put under investigation.
What's this criminal justice system you speak of? Where does that come from?
From the Constitution.
Where?
Well, us creating the courts. Or like creating the Supreme Court and then creating a Bill of Rights and then amendments afterwards and having like those rights apply to the states.
What was that to the president? He came first.
The president is still just a person. Like
Just a person, really?
It's I think of it from like a military aspect. Like you respect the title. It doesn't really have to do with like the person. Like just because Trump's the president now doesn't mean he's the president like next term. So we respect that office. We don't have to respect the person.
What's this with prosecuting him?
If the president is immune from prosecution, then it undermines the entire system.
Why?
Because then the system is designed to be fair and equitable for everyone.
So there's a phrase used, I think it's in the other case, but it comes up as well. Right, is the president above the law? This is Brian's question. I posed this as my lead-off question last year. Maybe it was better or worse, I don't know. I changed him because apparently you guys watch my videos and you can cheat. So I'll always make new questions, which is fair. John, what does it mean if the president's above the law? Let's just start there. What does that phrase mean? More generally, above the law. What does that mean, above the law? This is Brian's question, so you're answering his question. What does that mean, the president's above the law?
The law is enacted by Congress, applied.
Anybody want to take a step?
Like, he has a power that no one else has.
So Brian said he's just another person. Is that right?
Well, he does have extra powers that are like normal.
Yeah. Yeah, the president's a unique office. No other person is given powers by the Constitution than the president. The vice president can break a tie in the Senate. I think that's about it. It's the only power he has. It's a bucket of spit, right? But the president does have certain powers that no one else in the country has. He has the veto power you mentioned. He has powers over foreign affairs. He has powers over the pardon. Gabe, when you say someone's above the law, does that mean that the law treats every person equally? Why not?
Because the president is a person. He has, laws that apply to you, he don't apply to him.
Well, that's begging the question, though, right? So my difficulty with the phrase above the law is it presumes the law applies to everyone equally, which I don't think is the case, right? Exactly what the law is with respect to the president, that's what these cases are trying to answer. We understand that, right? No one's above the law, but the law for me is different than the law for the president. It has to be. He can do things I can't. I can't veto a bill. No matter how much I hate a bill Congress passes, my signature means absolutely nothing. Abdul, 1 second. I'll get you a promise. Right? So the question that Nixon v. Fitzgerald, and Clinton v. Jones asked is, what is the law as applied to the president? That's a far more useful question saying the president's above the law. It's a circular. I mean, it's good. It's rhetoric, but it's circular. Abdul.
I was gonna tell you, you're gonna know the right. So citizens of the United States aren't above the law. But the law applies differently to them than to, like, say, an immigrant, right? Someone who isn't a citizen.
Yeah.
We can say non-citizen, citizen, president.
Good.
They're all within the law because the Constitution gives the president certain rights or
Yeah.
powers.
Yeah.
It's not above the law.
Yeah, it's
a monarchy. So the president versus the monarchy.
Yeah, I think Abdul makes a fair point, right? If a person's in this country not a citizen, they can't go vote, right? They can vote for SBA maybe, right? But they can't vote for senator. You need voter ID for school elections, right? Your little ID card, right? Right. But I think Abdul raised a fair point. What does the law require is not the same for all persons. We have a provision in the Constitution that says equal protection of the laws. That's very nice, but non-citizens can't vote, right? Very easy example. There are a lot more I can give. But specifically, does the law here apply to the president differently, right? So if, Joe Schmo gets a subpoena in a criminal case, he has to follow it. There's not even a question. Here, the court says the president has a qualified privilege, right? There's no absolute privilege, but there's what's called a qualified privilege, which means case by case. If there's a national security reason, he can withhold the documents, maybe, right? If there's some sort of sensitive rationale, he can withhold it. But the court rejects absolute. If anyone in this classroom, right, gets a subpoena, you're following it, my friends. You can't turn it away. You can't say to the court, you know what? I am very important for national security. Leave me alone. Good luck with that, right? But the president, and the president alone can pull that off. I saw another hand somewhere. Yeah.
Do you think it would have been better for the court to be like intentionally vague here? Because now it just seems that a president could be like, this is sensitive to national security, I'm not going to turn that over. I need to be
Yeah, so I appreciate your question, right? Because was the court a little vague here? I think that's a fair question. What you have to remember here is a time in which this case was decided. Nixon was on the verge of either impeachment or resignation. They didn't know which one was going to happen first. And I think the court wants to speak clearly here with one voice, saying that you can't do this, right? I think the chronology is fuzzy, but I think he resigned within a week or two of this decision. It was fairly close in time. So this was like the last draw, U.S. v. Nixon. Once this case was decided and he realized he couldn't fight the subpoena, he stepped aside. Right? He didn't consider saying to the court, screw you, I'm not going to turn over the tapes, come and make me, right? Like with Roger Taney and Merriman, go send your marshal to the White House and see if you give me this tape, right? Knock on the White House door. Come and take it, right? Mullen Lobby, right? Can you come and take it? Didn't happen. Clinton.
I researched this last night and I couldn't find a definitive answer. Why did he destroy the tapes? They were his tapes. And
well, all right, let me, a couple things. He tried destroying them afterwards, right? There was another case, which I didn't assign, called Nixon versus GSA, the General Service Administration. After Nixon left office, he wanted to take all the tapes and basically bury them in his archive somewhere, right? And the government wouldn't let him remove the tapes from the White House. And the case of Nixon versus GSA was, were the tapes the property of Nixon or the government? And in a very funky opinion, which I don't think is correct, but it is what it is, the court said that the tapes were not Nixon's to destroy. So using Nixon versus GSA as a basis, he could not have destroyed them. That case was probably wrongly decided. It was a very weird case, but it was a product of the time. But as a political matter, why did Nixon destroy the tapes? He was convinced he was innocent, right? He thought he'd done nothing wrong, so why would he destroy evidence? I think that's the answer. I mean, you couldn't find a good answer. I'm speculating.
That was what I ran into. I didn't find this case surprising.
He was very paranoid and very arrogant. Yeah, because that's exactly right. But he was very paranoid, very arrogant. He probably thought one day these tapes will vindicate him. Maybe not. I don't know. Abdul and then John.
There is good evidence to believe that he knew he was lying. So when you talk about
he was fronting. He was like pretending on the tape to say.
Someone knows they're
Oh, okay. So
they wouldn't lie because like psychology, they've done studies on.
So okay. So what everyone Abdul's saying, right? Everyone already said. So maybe Nixon knew he was being recorded, was trying to clean up his act, right? John, I'll get you in a second. So we often cite James Madison's notes in the convention, right? What's not well known is that those notes were released very much later, almost 50 years later. And Madison actually edited his notes from the convention after the fact to make himself look better. It's true. He actually took speeches that other people gave and put under his own name. Specifically on the issue of slavery, that he toned down some of his own comments on slavery and imported some other abolitionist thought into him and put it in his own voice. We know this because, it's edited. You can check by the marks. People, cross stuff out. There's a book about this called Madison's Hand, right? How Madison's hand changed his own records. Maybe Abdul's, similar point. When you know what you're going to be saying is recorded, you say, "Oh, I knew nothing about this," right? And you're lying. Which is why I record everything. I don't ever accuse me of anything. I'm completely transparent at this front. It's for my own benefit, and yours too. But anyway, Josh, you said this. Okay, show me the tape, right? I never said it. It happens all the time. All the time. John?
Why the case by Best be Court of Appeal?
Oh. I'm not sure off the top of my head. If I had to guess, the president sought an emergency appeal to the Supreme Court. That's done in fairly rare cases where it's a really important issue. Oh, I know the answer. Yeah. So there have been 3 cases where the Supreme Court granted petition for certiorari skipping the Court of Appeals. One of them was Youngstown. One of them was U.S. v. Nixon. And third one was Dames and Moore v. Regan, which you studied last week. Those were the only cases, I might be wrong with this, but I think those are the only cases where the Supreme Court let a case come skipping the Court of Appeals. There might be a 4th case, maybe. The DACA case is pending now. The Solicitor General appealed straight from the District Court in California to the U.S. Supreme Court, and that petition's pending now. Might be granted, might not, I don't know. But the government said we've had this on 3 times, and this might be a 4th. But thank you for the question. Oh, yes, sir.
Is this really in any way, I see police officers working traffic laws all the time, and that's fine, I don't personally know, but is this really,
Okay. Well, so I don't have time to cover this any length, but there's a doctrine you'll study called qualified immunity. Okay? Qualified immunity. Okay? So let's say, a police officer pulls you over and he detains you for far too long without getting probable cause. Okay? You can sue him for violation of your civil rights. I think you studied 42 U.S.C. 1983. You familiar with this statute? Section 1983, which is called the Ku Klux Klan Act, allows you to sue state officials for damages if they violate your civil rights. If you go into any sort of civil rights work, that's your bread and butter. But in order to actually get damages against a government official, police officer, whatever, right? You have to show that they clearly violated established law, right? It's not that they made a mistake, that they screwed up. There has to be some clearly established rule that they violated, right? If they just made an honest mistake, they get what's called qualified immunity. It's not absolute immunity, right? But it's qualified, right? You can sue them if you show that they actually violated clearly established law. So this distinction between absolute and qualified comes up a lot in law, right? So if the cop, made a mistake and kept you an initial 30 seconds, and maybe the dog came a little bit later, probably okay. But if he knowingly kept you longer than he was supposed to, you can sue for damages, right? So this issue of qualified immunity does come up. But that's immunity to a civil lawsuit. Here we're talking about immunity to a subpoena, the judicial process. It's related, but not the same thing. Make sense? Okay. Other questions? Very good discussion. All right, so the holding, right? The holding in U.S. v. Nixon is that there is no absolute immunity for the president in the case of a subpoena, right? The conspirators had their constitutional rights to compulsory process and due process of law. As a result, the president's privilege falls.
Note, they say we do not consider civil litigation, right? If this was a civil subpoena, as opposed to a criminal subpoena, they do not resolve that question, which is very important. Right? So let's say someone sues, Joe Schmo, and they want to depose the president. They want to get a record from the president. The court doesn't resolve this here. Any questions on U.S. v. Nixon, the first case? Note, Justice Rank was recused Exactly why is not clear, but he was in the Nixon administration, and he probably felt a little guilty about stepping down. He served in the administration. Okay. So any questions on U.S. v. Nixon? Okay. Don't confuse U.S. v. Nixon and Nixon versus Fitzgerald. They're different cases. Students confuse them all the time. Who am I up to? Colby, my friend. All right. U.S. I did it. Nixon versus Fitzgerald. What are the... See, I told you exactly what not to do, and I just did it. Guilty. Colby, what were the facts in...
So Fitzgerald was a management analyst for the Department of the Air Force. He lost his job when they wanted to reform the department in order to make it more efficient with economy. He then later came back.
Well, but what were the circumstances under which he lost his job? Let's just be a little precise here.
It was reorganization and reduction of the department.
Is that the reason why he was fired?
No.
No. Okay, so tell me that.
They said he was fired because nobody really liked him.
Well, not just nobody. There was one person in particular who didn't like him very much.
Nixon.
The president, yeah. Okay, so
Nixon didn't like him, and he actually released a statement after the firing saying that it was he approved the firing and discharge of Fitzgerald.
why did Nixon say fire the guy? Or at least what's the suspicion of why Nixon fired the guy?
Wasn't going.
What did Fitzgerald do to get himself in trouble? What did he do? How did Fitzgerald get himself in trouble?
Well, he's talking about how cost overruns.
There you go. Yeah. So he blew a whistle, right? You know, if there's a whistleblower, he reported that there was cost overruns and they're spending too much money on these military projects, and that's basically why he was fired. Nixon, before there was Twitter, right? There were press conferences, and Nixon said, "I took responsibility. I was aware of Mr. Fitzgerald being fired. I approved it." And then he admitted on the White House tapes also. They didn't know this then, but it came out a little bit later. Okay? The White House said, no, retraction, right? Again, before there was Twitter, presidents made dumb statements in the press. There's nothing new, right? It's actually very important how the court treats Nixon's statements here compared to how some courts may treat Twitter. But we'll put that aside for now. Okay? All right, so Nixon more or less approved of the termination of this guy. Okay? Everyone with me? All right. So then Fitzgerald filed a lawsuit, right? Matt, what was the basis of Fitzgerald's lawsuit? What did he allege? Right, and then what was Nixon's role? I mean, specifically, what was the allegation of Nixon's involvement? No, I know, but what was the nature of the civil lawsuit that Fitzgerald brought? What claim did he bring? There's a specific claim he brought. Why? I mean, Nixon didn't fire him personally, right? The president doesn't say, you're fired, right? His boss did. But what was Nixon's role in this litigation? Scott?
His role.
What do you call that? Where some people are involved in a process that results in this guy getting fired. What would you call that? You got it, Matt? What's that word? You know it.
Yeah,
What? Yeah, Scott? Anyone? Conspiracy, yeah. It was a conspiracy. Same business as the U.S. v. Nixon case, right? But that was a criminal conspiracy. This is a civil conspiracy. And the conspiracy was to deprive him of his lawful employment. That they basically, conspired, right? Conspiracy. They conspired together to can this guy for engaging in protected behavior, which is reporting the cost overruns. Okay? So again, Nixon was out of office. Was this 1982, 83? 82, yeah. Nixon was out of office by this point. He was a former president, but this litigation was going on for year after year after year. So he couldn't say, you can't sue me because I'm the president now.
That wasn't an option. Instead, he said, you can't sue me because, Scott, what was the reason why Nixon couldn't be sued? What was his defense?
Because that was during his time in office, he was acting within his presidential duty.
There it is. You just gave us a test, right? So Nixon says, when the president is acting pursuant to his official duties, right? When the president is acting pursuant to his official duties, he has an absolute immunity from civil suits. Wait a minute. I'm sorry, I can read Kimmy, the really little letters. Kimmy, right? Kimmy, how can the former president assert a privilege? He's not the president anymore. How can he even assert this privilege?
Well, he was saying that as the former president, he was held absolute immunity over incidental power.
But how can the former president assert an immunity? Explain that part. No. You're not getting away that easily. How can a former president assert an immunity when he's out of office? What gives him the right to assert that immunity? Let me try another way. There it is. You got it. More. Yeah.
Because the claim happened while he was president.
Exactly. Everyone heard what Kimmy said, right? The reason why Nixon claims immunity is not because he's president now, but when the alleged conspiracy took place and he got fired, he was president. Right? That's the important point of this case. The immunity arises when the conduct occurred. When the guy was fired, Fitzgerald, Nixon was president. And therefore, the immunity attaches because he was president at that time. In other words, Nixon says, my actions, when taken in their official duties, are immunized. Right? You have an immunization, right? That's where immunities comes from. My actions taken while I'm performing my official duties are forever immunized. This is not a statute of limitations argument, right? That you can't sue me until I get out of office. It's you can never sue me for official duties taken while I am president. Okay? Everyone understand it? This is different than U.S. v. Nixon. Again, U.S. v. Nixon was an immunity to respond to a subpoena in a criminal case, and this case is a immunity from civil liability for official duties. They're different claims, and don't get them confused. Everyone get that? Everyone is with me, right? So Nixon says, I need perpetual, forever civil immunity from any actions taken in my duties, my official duties while in office, right? So Michelle, why would the president get, or what's the rationale for giving the president absolute immunity for actions taken in his official capacity?
Isn't it because the idea of separation of powers?
Okay.
He has executive power.
Right, but he's not president anymore, right? What's the big deal of dragging the former president to court? He's writing his memoirs, right? Chilling out in California. The reasons why you can't subject him while he's in office, I get that. But he's not in office. He's writing his memoirs and doing whatever Richard Nixon does, right? What's the rationale why you're still giving absolute immunity for these acts? It is what Kimmy said, yeah. That's exactly what I was looking for, in fact. Tell me more.
I mean, he's not president anymore, so why is he being...
That's my question. That's exactly my question.
I mean, his job is already done.
It is. It's done. He's out of office. He's chilling by the beach, right? Then why do we still give this immunity? What's the rationale why? You're actually really close.
I don't want to say it's unfair, but I feel like given that he's
Okay, Michelle, I'll stand you just for another minute because I think you want to get closer, okay? What if Fitzgerald had sued Nixon while he was still in office? right? It didn't happen. He actually was sued, but the case bounced around for years, right? What would have happened if, Michelle, he was sued while he was in office? What would have happened then? He was still president. He was still in office. And he was sued then. But that's the question, right? That's the question. It doesn't matter whether the lawsuit was brought while Nixon was in office or after. The principle is the same, right? If the president's acts are immunized, they're immunized forever, right? It's not just saying, we'll immunize your acts for the next 3 to 7 years. We'll immunize your acts forever. But the reason why is important, right? So we spoke in the last case, right? And I think Warren and I had this discussion. If you know your advice to the president's going to be recorded, it might wind up in court, you might not be candid. You might not be honest about your advice, right? You might be chilled. You might be hesitant to advise the president. Yeah, you know what, Dick, you're breaking the law here, but we can defend you, right? You're probably not going to say that on tape if you know you're going to wind up in court one day. Now, Sam, what happens if the president thinks that the actions he takes in his official capacity might drag him into court with a civil lawsuit? What might the president do or not do?
It definitely affects his decision-making process.
There it is, right? Why would the prospect of civil liability affect the president's decision-making process?
He can't be more efficient or aggressive when making decisions.
Or maybe might say vigorous, as Hamilton would say, or energetic, right? I think Sam's exactly right. If the president knows that he might be dragged into court for every little stupid thing he does, he might say, you know what, screw this. I can't afford these civil lawsuits. I'm only being paid, whatever the salary is for the president. I'm going to be passive. I'm going to take a step back. I'm going to be restrained. I am not going to do these things that I would probably otherwise do because I'm afraid of civil liability. That's the basis of the majority opinion, right? The rule of absolute immunity immunizes the president and gives him carte blanche, free range to do what he would otherwise do. But if the immunity was qualified, right, meaning a court decides later on whether or not the act was within his duties, that could chill the president. That could make the president not do what he wants to do. And again, this is Brian's question before, is the president a regular person? Or does he have certain special privileges? And the majority, without fail, Justice Lewis Powell says, he is special. You're all special. No, he's special, right? Even if he's not in office, the court's saying we do not want to burden, we don't want to shackle the president with additional constraints that might impact our republic in a very bad way, right? We don't want to divert resources so that the president has to investigate. Oh, maybe I'll get sued, maybe I won't. Have to go sit for a deposition, right? Have to go produce evidence. Okay? Jonathan?
Well, as long as he's in the scope of his duties, but that's always changing. Like now, is him giving a speech in public within the scope of his duties?
Oh, what a good question. Right? What a good question, right?
I'm just thinking about what he did to Kathy Griffin or Nordstrom, what's currently going on. It's like, well, he's giving a speech, that is one of his duties, but it's actually negligent and tortious.
So what Jonathan raised, and I'll get you in a minute, what Jonathan raised is a very good question, which I'm actively involved with in various litigation, right? Is the president always acting in his official capacity?
Under respondeat superior, sort of.
Well, who is the superior?
The office of the presidency, and he's the employee as the president.
So the question is this, right? If the president is walking down the street, right? He's on his golf course, whatever, right? And punches someone. Just guess who'll find the golf course and punches someone. Is that in his official duties or not? If the president has a side business and is receiving royalties in a book or a real estate property, is that within his official duties? So you haven't learned this, but there's a doctrine in law called official capacity, right? I'll use the example Herberto asked before about a cop who beats you up, right? When a cop beats you up, right, he's no longer acting just in his
official capacity. It's also an individual capacity suit, right? He went beyond his duties as a police officer. So when the president exists, and this is my argument, this is actually being litigated now, does he exist only in his official capacity 24/7? Or does he have individual actions? That is, are there certain duties that are not performed pursuant to his office? And here's the key. If the duties aren't performed to his office, he's immunized. If the duties are outside that scope, he doesn't have immunity, and he can be sued, which is what happened to Clinton, right? Again, Bill Clinton, we'll get there later, committed sexual assault against Paula Jones before his inauguration. But what if he had, molested an intern during his office, and Monica Lewinsky brought a claim against him for sexual harassment? Would that be pursuant to his official duties? I guess it was in the White House, perhaps, right? Maybe discussing government business. But at some point, having a sexual relationship with an intern is probably not government business, which is what I think actually brought him down. So can the president have individual capacity torts, right? Individual capacity torts outside of his duties? If the answer is yes, then Nixon v. Fitzgerald would not serve as a bar. Does that get to your question a little bit? This is being litigated now. I'm actually writing briefs on this in the Foreign Emoluments Clause litigation, which I'll mention very briefly. I don't like this class being current events. There's so much for you to teach, but I'll leave this day aside because it lends itself well. There are allegations that the president is violating the Constitution by accepting business profits from both states domestically and also foreign nations. I've written this in brief, so this is my informed opinion, that the president accepting these profits is not in his official capacity, it's his individual capacity, that there's no government policy is affecting, there's no government property, it's just coming to his private bank account. If these are individual capacity suits, then the clauses don't apply to him in the same fashion. There has to be other things which I'm not going to bore you with, but the plaintiffs in this case sued Trump in his official capacity. I've argued those complaints are not properly pleaded. But this is a live issue about the scope of Nixon v. Fitzgerald that I think will resolve very soon. Brian, patiently waiting. I'm sorry I kept you so long. And then Laura, I saw your hand up as well. Yep. Okay, we'll get to White in a minute. Okay, so what do you like about White's dissent?
The majority is basically reverting back to the idea that the kings are doing wrong. Essentially granting sovereign immunity to the office of.
Very good. Okay, we'll get back to White in a minute. I want to get Laura's question. I'll do White, okay? Laura?
So because the president has immunity for conduct that they do in their official duties.
Good.
I know that the court in Clinton did mention that they're balancing the different Anyway, my question is, if the president was on his way to a conference or whatever to perform their official duty and get into an accident, just hypothetically, because of Fitzgerald's ruling, would the injured party not get compensated at all?
I mean, the president doesn't drive the car, right? Which he's usually not driving the beast, right? The presidential limo. But to use your example, right? Let's say the president's, at a speech and he slanders someone from the lectern, right? Let's say he's giving an official speech and he slanders someone. All right? Better one. Let's say the president's giving the State of the Union address and he slanders someone. Let's say the president incites violence, issues a threat, right? There's First Amendment issues, but threats not protected. Neither is slander. Neither is libel. The line of where the president's acting his official duties will become apparent very soon. I've been pushing this for a few months now. But where exactly that line is not clear. Clinton v. Jones doesn't answer it nearly, because it's an act that took place before he was a president. What makes this entire area so tricky is that there's so few lawsuits brought against the president. They just don't happen. Justice Stevens said, I'm not worried about this lawsuit because no one's going to sue the president here, right? That prediction did not pan out. I think Denny has hand up, and anyone else have their hand up? And then Witt. So Denny and Witt.
Well, does the congressman can go on for the Senate and pretty much say whatever they want. Does that inform us anything on the situation?
So there's something called the speech or debate clause in the Constitution, which lets members of Congress speak freely without fear of prosecution. The president does not have such a provision.
He does have First Amendment rights, though. What?
I was curious, do removal powers have anything to do with this? Because I considered him to be like under the an official under the executive branch in the Air Force. So why does he not have the power to remove him?
So the Fitzgerald was not a principal officer. He was what's called an inferior officer. And Congress can put a lot of strings on the removal of inferior officers, even under Morrison, right? There are civil service laws, which if any of you work for the federal government, you should know, where you can't be fired at will for various federal government jobs. You have to have some processes and hearings and the like. So if this was like the Secretary of the Air Force, you'd probably be fired at will, but not for some random civil servant. Other questions? All right, let's do White's dissent. Brian mentioned a minute ago. Cameron, what's Justice White's argument here?
Well, his big thing is we're talking about line. You're talking about him being above the law.
Yeah.
About the whole, fair justice and inherent things of the regarding value not immune from criminal acts. It's different here. And then what happens to those who have realistic actual claims?
Right. So, I mean, here's the bottom line. Mr. Fitzgerald is screwed, right? Fitzgerald had a legitimate cause of action, but because of this absolute immunity, he's got zero, right? Kendall, how does the majority respond to this claim that the president is not, will not feel any pain from this? The president would just skate by. Is there any recourse against the president other than civil damages?
Yeah, they were talking about, they kind of used it in their reasoning for like why there should be immunity. They were talking about like the basically not criticized every day, so we may not have a lawsuit for this specific type of thing, like allegations that we have to make sure that it's not like suffered.
Very good. So here's the debate, right? The dissent says Justice White, poor Mr. Fitzgerald, there's no remedy. The president goes by for committing, malfeasance, right? The majority says that's not true. There's presidential scrutiny. There's impeachment is always an option, right? Is the president going to be impeached for firing Mr. Fitzgerald? Of course not, right? He's not that important, right? Is public scrutiny going to make a difference in the president's conduct? Maybe, maybe not. Will paying however many thousands of dollars of damages make any difference? Maybe, maybe not. But the point that Justice White makes, right, is that this does indeed treat the king as if he had sovereign immunity. In the same sense that states can't be sued, right, 11th Amendment, right? In the same sense that states cannot be sued, the president now has the same stature for his official duties. Yes, Amber.
I don't really know where this fits in, but it seems kind of insane to sue the president.
Insane? Why?
Well, it's way bigger than, like, unfortunately for this guy who got fired for his job because the president doesn't like you, like, I understand like the type of situation, but the office of the president is way bigger than that. If you're trying to negotiate with like foreign leaders on issues over like nuclear weapons, and I mean, I know I'm getting like to a current situation, but and if you
do you think Mr. Fitzgerald brought this suit really motivated because he lost his job?
No.
Why do you think he brought this suit?
I think he just wanted to bash the president publicly.
Okay, and this is a point that Stevens addresses in Clinton v. Jones. He says, Amber's point, right? The president is attacked on political fronts every minute, every day, in 280 character bursts that you can imagine, right? Every president, not just this one, right? A lot of people who sue the president don't really care about the issue. Maybe they do, but it's primarily about trying to frustrate the president and get political damage, right? What Fitzgerald really wanted was discovery. When you want the president under oath and he perjures himself, okay, that's what you get impeachment for, right? You don't impeach him for firing Mr. Fitzgerald. You get him under oath, right? Which is why discovery is such a big deal when these civil suits go on. Even if there's no liability, right? Even if the damages are a few $1,000s, the key is discovery, right? So there are lots of litigation, lots of lawsuits against the president now, and the primary motivation is discovery to get him under oath. The court here is trying to immunize the president from that, so he doesn't have to worry about that. Because once you get him under oath, and if he lies, That's perjury. That's what happened to President Clinton, right? The Paula Jones case subsequently had a grand jury investigation where the president lied about his relations with Lewinsky. That's what comes up, definitely.
I just wanted to ask if it would be plausible that Fitzgerald got like forced into bringing the suit to test this.
Who do you think was paying his legal fees? Think he was paying himself? No. There's a cottage industry of law firms that are free to sue the president. In the last 8 years, the conservative firms sue the president. Now these liberal firms sue the president. It's very common, right? There's nothing new under the sun. Right, Cameron?
Maybe I missed it. How exactly do the dissenting judges view their own immunities?
Okay, well, Reen, what's this deal about judicial immunity and prosecutorial immunity? Did I say it right? Oh, the Raven. I'm sorry, Raven. I said 2 E's. Sorry, Raven. What's this business about judicial immunity and prosecutorial immunity that Cameron just brought up? Because it's mentioned at the end of a majority opinion. Right? If a judge issues a ruling against you, can you sue the judge for screwing up? Raven, can you? Why not?
Because it is up to the court to decide whether
No. If a judge issues a sentence against you, can you sue the judge for screwing up? Even if they say the sentence is overturned on appeal, can you sue the judge for screwing up and give you a bad sentence? How come? If the Supreme Court justice makes a mistake in their ruling, can you sue them? Why not? Malia? Bingo. Judges have absolute immunity. Absolute. This one's not qualified. If a judge gives you a criminal sentence and is later overturned an appeal, you can't sue him for screwing up. Can you imagine what that would do to the judiciary if every time they give a sentence that was overturned, they got sued for damages? Can you imagine? Courts would go out of business, right? They go out of business. Same for prosecutors. If a prosecutor brings a case against you, and let's say you're convicted in the trial court, and it's overturned an appeal, can you sue the prosecutor for making bad charges? No. There's something called malicious prosecution. That does exist, but that's something very specific when the prosecutor brings these really, really bad charges. As a general matter, judges have absolute immunity, prosecutors have absolute immunity. So Cameron asks, why can't the president? Now again, police officers have qualified immunity, right? This is Herberto's question a minute ago. But judges have absolute immunity? The prosecutors have absolute, but not the, but I guess the president does. Yes, Damon, and then Herberto?
These immunities of judges and prosecutors have also is limited to their official acts.
Yes, right. So for example, if a judge issues a sentence, right, and he's overturned an appeal, you can't sue him. If a judge, say, has a law clerk whom he sexually harasses, that's not his official duties, and he can be held liable for that. Right? Herberto?
Very briefly, what about Mayor, like Mayor Zillow?
What about him?
I think he will get qualified.
I think so, yeah. I mean, he's usually not the one committing torts, but assuming he is, he would be the one, yeah. Like, you can't sue the mayor because you don't like him or disagree with his policies. That's not a ground for a civil lawsuit. Samuel?
So one of the big aspects of the president is that he's accountable.
And that's what the majority responds, is the president does have political accountability. But here he's a former president. He can just go and disappear into nothingness. Right?
So the mayor has absolutely
No, qualified.
Oh, just like the president.
I think the mayor is treated like other government officials in Houston. I don't think he has any sort of absolute immunity. But he's qualified immunity for sure. I mean, if the mayor, is at a speech and trips and falls and knocks someone down, right? I think you'll probably have qualified immunity for that unless it's deliberate. There was one footnote I want to mention, the story between Aaron Burr. This is a fascinating story in American history. We often talk about Marbury versus Madison, where we say,
If Marshall had ruled against Jefferson, Jefferson would have ignored Marshall. We often say that. This case, though, suggests that might not be entirely true. So what happens that Aaron Burr, right, the same Aaron Burr who was vice president, the same Aaron Burr who shot and killed Alexander Hamilton. Aaron Burr was charged with treason. He actually tried leading a revolution against the United States, but he's a bizarre figure. But after he was vice president, he tried leading basically a revolution against the United States. It's a really weird case. He was charged with treason. Who presided at his treason trial? John Marshall, who was riding circuit in the circuit court for Virginia. And recognize that of this kind would a court be required to proceed against the president as against ordinary citizens. But this issue came up. Burr wanted some documents from Jefferson that could exonerate him. Jefferson said, screw you, not going to do it. The court gave a subpoena, ducis tecum, to President Jefferson. Jefferson complied with some of them, but not all of them. So from this, the court says the president might be subject to some judicial process, right? But that there was this fact that basically the court ignored. So Jefferson ignored some of the subpoenas. Okay. Whatever the answer there, though, is that the president can be subject to the subpoena, which was U.S. v. Nixon. Here, damages are of a different nature, and there was no precedent of the U.S. president ever being subject to civil damages in court. I'll focus briefly on Chief Justice Berger's concurring opinion, where he says that the courts must be hesitant to probe into the president's decision-making, right? Because think about this, right? Greg, let's say that Mr. Fitzgerald got the discovery, right? Let's say the case went ahead. What would he try to figure out? You're his lawyer, right? What would you try and figure out from the president if you got discovery? You can depose the president. What would you try and figure out? You're Fitzgerald's lawyer. Implicate the president in what? Implicate the president in what? Well, again, so Greg, what was Fitzgerald's problem in the first place? Why was he suing? Up here, look this way, yeah. Well, why was he suing? Very good. So if you had the president under oath in a deposition, what would you try and ask the president? What's your first question you ask the guy? Why? Okay. And what will that question implicate, right? In order to answer that question, what's the president have to talk about? Okay. Internal executive branch deliberations, right? The very nature of this case is, so why'd you fire him? Oh, you guys had this conversation in the White House. What was this conversation? Oh, it was about the Air Force. What'd you talk about? Right? It requires a discussion of some pretty delicate and sensitive internal deliberations. Now, I think this is to Amber's question before. Chief Justice Berger says it very bluntly, that this can be used as a means of extortion. Right? Right, Amber? That's what Berger says. It's diverting the attention from the president. And we need to prevent an invasion of the executive function by the judiciary. What's that mean, extortion? Steve, what does that mean? This can be used, litigation can be used as extortion. What does that mean?
Just like scrutiny and harassing the president.
Yeah. Yeah, if the president knows he's subject to a lawsuit, he might not be able to be president very long, because every single one of his actions is subject now to judicial scrutiny. So the concurring opinion makes this point, I think, fairly bluntly, far more than does the majority opinion. Justice Berger was always very blunt. That was his style. He was a very poor Chief Justice, wasn't well liked. Rehnquist was much better. But Berger was not well liked by his colleagues. All right. All right. Any other questions then on Nixon versus Fitzgerald? I keep doing it. Nixon versus Fitzgerald. Yes, ma'am, Regina.
Reading what you said, it was just a thought that I had.
Yep.
Sure. It seems like the taxpayers pay the president's salary.
Right.
course, in this case, our president has other sources of money. But if we sue them in a civil case, it's like we're collecting from ourselves and suing our fellow.
Well, actually, no. It comes from the president's pocket. So the president's salary, Google it, someone, I think it's about $250,000 a year. It's under 300. I mean, that's a lot of money. I mean, it's less than what they were making before, right? If he starts suing the president for lots and lots of money, he might not be able to afford it. Right? This is the reason why lawsuits against police officers are tough, because it comes out of, well, it can possibly come out of their own pocket. Usually the union picks it up. But in theory, if you start suing police officers for their own pocket, they may not be able to afford it. And they'll say, you know what, I'm going to not be an aggressive police officer because I can't afford this. Now, that might be a good idea, right? That might be good. But the problem becomes this. If the police officers aren't doing their jobs well because they're afraid of liability, and perhaps it's a safety issue. So, again, if the president is afraid of civil liability, he may not be a very good president. And that ultimately harms all of us. But to answer your question, Regina, if Nixon had lost his lawsuit, the money would come out of his own pocket, I think. Now, there is a law, and this doesn't come up very often, that if you sue a member of Congress, there's a law called the Westfall Act, which allows the government to substitute the United States for the congressman. So in other words, the money comes out of the U.S. Treasury and not out of the person's pocket, right? I'm dubious about that, but it does come up. One more second. There was a case, a congressman in Pennsylvania, a guy named John Murtha. He slandered a bunch of members of the army. He said these guys were murderers and they killed people, right? He slandered them. The family members of these slain soldiers brought a lawsuit against Murtha. And what happens is they substitute the individual for the United States. They bring up sovereign immunity and the case was dismissed. So it's very hard to sue members of government. I don't think the president can do that, but it does work for Congress. Whit.
I was just curious, I know it's more procedural and not really with the immunity, but it said in Berger's concurrence that he was reinstated and he got back pay, so what damages does he actually have?
I'm sorry? Right, so he wasn't actually only suing for damages. Under the District of Columbia law, there's a tort of civil conspiracy. So the fact that the conspiracy existed resulted in his termination, that gave him an injury, right? But he wasn't just suing for back pay. DC actually had a cause of action for this. Right. Yes, ma'am.
I just want to be clear. So the president is not immune to the criminal case?
This is not a criminal, right? This was a civil case. Be very careful.
Yes. So I'm just going back to the criminal case. And then he had to answer to the subpoena
Yeah.
that Nixon had.
Yeah.
So what if he prosecuted? Like, can he be prosecuted in the criminal case?
Well, isn't that the other question not answered by these three cases? Right? Everyone heard Min's question, right? Here are our three cases for today. Okay, here are three cases for today. Number one was U.S. v. Nixon. Can the president block a subpoena for someone else's criminal trial? The second case, Nixon versus Fitzgerald. Is a president immune for acts taking official duties? The answer is yes, absolutely. The third case, can the president be sued while in office for a civil matter? Now, Min's question is one I don't have up here, which I won't venture a guess. Can the president be prosecuted for a crime while he's in office? And I'm going to twist that. In a state court or a federal court? This is my final exam question last semester, by the way. Could the president be prosecuted in a state court for violation of state law while he's in office? That was my final exam question. You're welcome to take a look at it later. But I don't have a good answer for you. It's a very, very hard question to answer. Your hand? All right, you guys handing? I can't tell. All right, so any other questions on the majority, Justice Berger or Justice White? Justice Blackmun, again, no relation, had a very brief dissenting opinion. Oh, one note. If you notice the very end of Justice White's dissent, he wrote, I dissent. Not I respectfully dissent, I dissent. That is like the mic drop, okay? It's a very distinct
act of a justice when they really are pissed off and they want to signify their outrage, they say, I dissent. Boom, period, right? I did the math. Scalia and Ginsburg are the most common offenders of this. I think Ginsburg will now probably break the record. But saying I dissent is a very angry act. Justice Blackmun, Brennan, and Marshall said that this court leaves unanswered its argument that no man, not even the president, is above the law. Right? I thought this was a foundational principle of our jurisprudence. Now the president's not subject to supervision. Okay. So any questions on Nixon v. Fitzgerald? Nixon v. Fitzgerald. Important case, although as a couple of you hinted at, it doesn't define official duties. And that I think will be litigated extensively in the next couple of years. Yeah, the good part of this class is, stuff always comes back. Nothing's ever resolved for sure. Always something new in this world. Any other questions on Nixon v. Fitzgerald? Okay, Ambrose, yes, sir. All right, give me the facts, please, in Clinton versus Jones.
So Jones was a state employee from Arkansas.
Good.
And she was working the registration desk where the then Governor Clinton was giving a speech.
Good.
She was approached by a state police officer.
Yeah.
And was kind of convinced to come up to the business suite.
Yeah.
And then she claims that the governor gave some sexual advances that she rejected. And so she got her damages of $75,000.
Okay, let's just get a chronology down. What year did these allegations take place at the hotel? 91, okay. Clinton was elected in 92, November 92. He took the oath of office in January of 93. Ambrose, when was this lawsuit filed?
May 6, 1994.
Okay. 94. So just chronology, right? The assault happened in 91. Clinton was elected in 92. Took the oath in 93. Lawsuit filed in 94. Herbieta, why did she wait so long? Why didn't she sue him when he was still governor? Is that anywhere in the fact? It's not in the book. I'm at. What? Why didn't she sue him before he became president? It's the time, 3 years to file a civil lawsuit. I mean, the allegations are pretty straightforward, no? Don't you want to file right away, get your statute of limitations going?
Yeah.
Yeah, I don't have an answer for this, right? I really don't. What I will say is she waited till he was president to file the lawsuit, right? That's significant. Had she filed the lawsuit before he was president, it would have been a very different matter. Because a governor, like the mayor, has only qualified immunity. And he probably would have been on the hook for damages. But she waited till after the election and the inauguration. Okay? She actually filed it in Arkansas District Court with diversity jurisdiction. She was the citizen of Arkansas. I'm sorry, she was actually California at that time. So she sued in federal district court in Arkansas. Okay. Immediately after the case was brought, President Clinton advised the district court that he would file a motion to dismiss on the grounds that the president has immunity. And he wanted to defer the entire litigation until after his time in office. In this case, it would have been, and we didn't know at the time, but he would be reelected nearly 6 or 7 years. Okay? Now, Kelly, did either... Oh, Dame, was your hand up?
Yeah, just quick question. So this was a sexual harassment case which brought diversity to federal court. So how did they calculate the damage to be about $75,000?
You will be a lawyer one day. When you want to go into federal court, your calculation of damages at the complaint stage doesn't have to be very precise. You have to show a general basis of how maybe in other sexual harassment cases these sorts of damages were in that ballpark, right? But the damages are not calculated until after the jury reaches a verdict, right? So it's entirely possible that even though you brought diversity by saying it's 75,000 at the outset, the jury might award 10,000. You don't get tossed to federal court. So the complaint at the outset doesn't have to be very precise about $75,000. Make sense? I've even seen cases, these are nuts, where the plaintiff says, our legal fees will be $75,000. I don't think that's valid, but here they allege at least 75K. Okay, Kelly, that was my question, right? So he says, I have immunity, and I want to put all this litigation on hold till after I'm out of office. Is there any precedent that he could rely on to make that sort of ruling, that either U.S. v. Nixon or Nixon versus Fitzgerald? Is there any court case which says that you can't sue a sitting president? No. So what was Clinton's basis for making this argument that you had to postpone the cases till after he's out of office? Right. So we have to appreciate this case was not governed by any other case, right? Again, U.S. v. Nixon, the first one, right, was about someone else's criminal trial and the president receiving a subpoena. The second one, Nixon versus Fitzgerald, was about the former president being sued for his official acts. There was no Supreme Court case on point about whether the current president could be sued while in office. Now, Elena, was the sexual harassment allegation, were those his official duties as president? Why not? There's a really easy reason why. Why were the allegations not part of his president's official duties? There it is, yeah, that's right. He wasn't in office yet. So this is definitely not Nixon versus Fitzgerald, number 2, because he was not yet in office. Right? He was not yet in office. Okay? He wasn't in office yet. All right, everyone with me? So this was a new case, and the court had to resolve this on a blank slate of judicial precedent. But this was not a case where there was no precedent at all. All right. Briefly, note footnote 13, somewhere in your book, somewhere in the case, somewhere on the page. Footnote 13. You have that?
698.
Sorry, yeah, 698. Thank you. The court discusses, could this claim be brought in state court? They say, well, this was brought in federal court, diversity jurisdiction, we have to worry about it. At this very moment, there's a lawsuit pending in court in New York where an allegation was brought against President Trump for sexual harassment, for conduct before he was in office. And they sued him not in federal court, but in state court. And the president moved to dismiss the civil lawsuit, saying that you can never sue the president in state court. Why? Well, they cite footnote 13, which doesn't answer the question. They say under the Supremacy Clause, state courts can't control the president. But is that right? I don't think the Supremacy Clause gives you an answer here. I think this was actually also part of my exam question last semester. I think it's an open question whether the president can be sued in state court under Clinton v. Jones. My only hesitancy is actually McCulloch v. Maryland. That case always comes up, doesn't it? You'll recall that Maryland tried putting a tax on the federal bank to destroy it. And Marshall said you can't have a state institution destroy a federal institution. It doesn't work like that. As a general matter, if state courts handle these cases in a responsible fashion, there's probably not much of a threat. But you can imagine a state court tries to take down the president. Reasonable. There may be Supremacy Clause problems there in McCulloch, but this is a live issue now. I put that aside. We don't have that here. It's a federal court question. So the first question, right? Who am I up to? Min. With a civil lawsuit, Does the president have to go to court? If I sue you for a battery or something, right? Are you required to show up in court? What? No, you're not. You can have your lawyers do it for you. So in this case, would the president? Does the court say the president will be required to show up in court for this civil lawsuit? Exactly. Right. So one of the factors the court relies on here is that the president would not need to be personally in court. Why? Yeah. Why? The reason why is because in a civil lawsuit, you don't have to be in court. Right? The president has a very busy schedule, right? Running around, talking to people, doing whatever, right? Dragging him to court takes him away from his responsibilities, right? Imagine, right? The president's sitting there in trial and North Korea lobs a nuclear missile at California. He's like, Your Honor, I need a brief recess, right? No, no recess. Okay. That would be a very bad idea. Again, someone asked me before, can the president be prosecuted with a criminal trial? He would not be able to do that, though. The president needs to be present at his criminal trial, which is one reason why I don't think you can try a president for a crime during office. Maybe try him afterwards, but not during office. So the court says, look, there's no reason to compel him. And in terms of discovery, right, what if, oh God, the orange highlighter. Ruben, I need a black highlighter. I can't read that. Ruben. It's like my vision test. One or two. Okay, Ruben. What if the president needs to be deposed, a deposition? Does that need to, is that an intrusion on the president's authority?
They said that he could do that in his office, but they can go to him whenever it's convenient.
Okay, very good. Right. So the fact of the matter is, the president can take a deposition at his own office, on his own time, and the courts can be sensitive to that. Moreover, there's evidence that other presidents have given depositions, and President Jefferson did give testimony in the Aaron Burr trial, right, by written, but he gave at his own time. So the court basically says there's no real reason why the president should be immune from litigation, so long as it's done in a way to respect him. Again, this is Brian's question. Can anyone else demand a deposition of his office? No. The president can. So they're saying is you can treat the president a little bit special, but not absolutely special. But Clinton's big claim was one of temporary immunity. He wasn't asking for absolute immunity. He wasn't saying, I can never be sued for harassing Paula Jones. What he says is, you can't sue me while I am in office. Put the matter on hold. Bring it back when I'm out of office. The court says that only a couple presidents have ever been sued, and none of that litigation ever settled. Now, Kenny, why do you think this case didn't settle out of court? Quietly. I mean, I don't know the answer for sure. Ask Paula Jones, but what, just want to take a guess. Why do you think Paula Jones didn't want to settle this case out of court? Probably. Yeah. And I don't mean that in a callous fashion, but when you're suing the president, the usual incentives for settlement aren't present, that there is a political motivation. Same with Fitzgerald, right? Nixon maybe offered to settle the case, but he wasn't interested. In past cases, presidents have been able to settle, but not here. So there is that political element, but the court allows it to proceed. Okay. Now they look to history. We know that Jefferson eventually complied with the subpoena, even though he complained about it. There's some conflicting records, but nothing in the text or structure of the Constitution allows the president to forestall or postpone these cases. Okay. All right. So, question so far. Is it John? No, Sam. Sam, sorry. Sam, what though is the risk that Justice Stevens recognizes of dragging the president to sort of civil litigation? There's a risk the court recognizes.
Is it the separation of powers thing that having him have to deal with, I guess, things in like the judiciary would take away from?
Yeah. So the problem is that this litigation may impose an unacceptable burden on the president's time and energy and impair the effective performance of the office. For most people, if they're sued, whatever, your job's not that important. No offense, all of you, you're not that important. This guy they're saying is, right?
And if litigation does get in the president's way of performing his national duties as commander-in-chief, that's problematic. But they say, Justice Stevens writes, if the past is any indication, it seems unlikely that a deluge of such litigation will ever engulf the president. Yeah, right. He's probably backing off that statement right now. And there were a lot of people in the 90s who said this case is going to be a disaster. Maybe not. But they say, even though that there's a risk of politically motivated litigation, it can be handled quietly, and there can be sanctions. All right. So questions on Clinton versus Jones. Hey, Cameron.
They talk about at the end how if they wanted, Congress could pass a statute.
Oh.
Did they ever try to do anything?
No. So what's that going on? The federal courts are courts of limited jurisdiction. Congress could pass a statute saying the federal courts are disabled from hearing any lawsuit against the president. They can do that. Congress could pass a statute saying we hold any statute of limitations till after the president's out of office, defer the case. Congress could do that. They have not done so. But this is why the state court issue is so pernicious, right? If state courts can assert jurisdiction against the president, either civil or criminal, Congress is helpless. And only the Supreme Court can then intervene. Again, I've been just my final exam fact pattern last semester is a state court judge in New York sentences President Trump to jail. Trump's lawyers say, can you please put this on hold? We want to take an appeal to the Supreme Court. And the judge's like, no, bailiff, take the president. And there's this dramatic scene where the bailiff comes up with his gun drawn, and the Secret Service says, we have our guns also. And then the question was, you're the lawyer for the president, what do you advise? Now, I think a responsible judge would say, okay, I'm going to rule against the president, let this appeal up to the Supreme Court, let a more important judge, right, actually make his decision. But there's no guarantee. And even if the president's incarcerated for like 5 minutes, that's when Kim Jong-un launches a missile, right? So these are really tough questions about whether the president can be indicted while he's in office, charged while he's in office, tried while he's in office. If not, can the president pardon himself? I'll get to the pardon thing in a minute. Any other questions on USB? I'm sorry. Clinton. I warned you to say correct when I keep screwing up. Clinton versus Jones.
So I just want to be clear, if he had done exactly what he did, following Jones while he was president, it's not clear that he would have brought the suit.
Oh boy. So, would those be official duties? I don't think so either. Which is why I use the easier example, the president punches someone on the golf course, right? But I guess sexual harassment might be a similar thing. I don't think those are his official duties. I think he could be sued, notwithstanding Nixon versus Fitzgerald.
So then I have like a follow-up. It didn't matter at all that he did that while he was a governor?
Well, again, governor is qualified immunity, and no governor can sexual harass him. It's still tort. You can't do it. Jonathan?
So the president is still a person. He still has constitutional rights under the Bill of Rights. So how would he ever be guaranteed an impartial jury or a fair trial anywhere within the United States?
Right. Now you're bleeding to the next question, right? Can the president be indicted? Can he be tried? So Jonathan's question is, how can the president ever have an impartial jury anywhere? Right? 50% of the country hates him. Most presidents don't have much more. Juries like, oh, I know what that person is. Right? There are a lot of reasons why a criminal trial against the president wouldn't make sense. One of the reasons is, would he get a fair jury? But it'd be really tough to get a fair jury in this one. But I want to go back to Kenny's question, right? Can the president have private actions while he's in office? Generally, the president doesn't come into contact with people when he's in office, right? The only time he meets people is when he's acting as president. So there are very few individual capacity actions. But, your example, if you harass Paula Jones, or if you harass Monica Lewinsky, which actually did happen, could have been a civil lawsuit. That would have been allowed under Clinton v. Jones, and I don't think there would have been immunity for Nixon v. Fitzgerald. Right? By the way, what happened right after Clinton v. Jones? Then they settled the case for a lot of money. They made the case go away. So this case actually did settle ultimately.
for a lot of money. We don't know how much. It was a lot. Yeah, JC.
I thought Clinton went to trial for Ms. Jones. Mark Lewinsky actually gave testimony. She said he didn't do it. He got off, and then there was a tape submitted where Mark Lewinsky admitted to the affair with President Clinton, and then he settled.
I might have been shortening events. That sounds plausible. I don't know specifically, but eventually he settled this case.
I remember it was like reported $850,000.
Yeah, it was a lot of money. It was a lot of money.
What did he also disbarred for perjury?
I don't know if he disbarred or he voluntarily resigned. I think he resigned from the bar voluntarily. He was about to be disbarred. I think that's what happened. But yeah, but he did commit perjury because he lied under oath in the grand jury. And I think he did resign from the bar in anticipation of being disbarred. Anything else on Clinton versus Jones? Yeah, Brianna.
There's some allegations of harassment against Mr. Trump.
Yeah.
Anything to add there as far as if anything, the lawsuit going on? It doesn't seem like I don't hear a lot going on.
Well, I mentioned one of the cases. One of them, her name is Summer Zervos. It's like Zervos. Just check on the spelling. She alleged that Trump harassed her before the election, and that suit's pending in New York Supreme Court, New York State Court, which is exactly what footnote 13 raised. Can a lawsuit, civil, be brought against the president for conduct beforehand? Right. The emoluments clause litigation concerns conduct during the office, and what I've argued and others have argued is that this is not official capacity action, therefore it's not barred by Nixon v. Fitzgerald. There's some other problems with the lawsuit that are beyond the scope of this class. Other questions? So I assigned 2 articles about whether the president will be prosecuted and whether the president can pardon himself. And these are think pieces, right? Because it's never going to happen. No matter what delusional fancy you have, the president's not going to be indicted while he's in office. It's not going to happen. It's not going to happen. It's not going to happen. It will not happen. I promise you it's not going to happen. He might be indicted after office, but not while he's in office. But that makes it a very good question to think about in class and some of the difficulties. So structurally, right? Structurally, the executive branch is under the president. Morrison v. Olson said, we allow the special counsel because it's an inferior officer, right? The inferior officer's power is limited. He can't do whatever he wants. He's answerable to the Attorney General. If any independent counsel or special counsel tried to indict the president, what would the president immediately do? Fire him or resign, right? Either way, right? If the president was aware that a special counsel was about to be indicting him, he would order him fired. Now, whether the president can fire himself or tell the Attorney General to, someone's getting fired. Now you can imagine, the president tells the AG, fire the special counsel. Special counsel says, no, I'm not going to do it. I'm resigning. It goes down, right? Deputy, fire him. No. Eventually, someone will fire the special counsel. It's going to happen. So the indictment will not be brought. Even under the current arrangement with Robert Mueller as the special counsel against Trump, he can't bring an indictment by himself. Ken Starr could with Watergate. Ken Starr could. Mueller can't. So what if Robert Mueller says, I want to indict the president? And the Attorney General says, not going to do it. That's the end of the line. But state court, that's the biggie. What if a state court brings some sort of criminal charge against Trump for racketeering or something like that? Right? He can't fire the state attorney general. It's not in his chain of command. I think that very likely you might see. And if the indictment's actually brought, they may not even try him. They can just indict him now and wait till he's after office to bring the trial. Could the president move to quash the indictment now and go right to the Supreme Court? I think they would validate the indictment. Even if there's no trial, right? So just logistically, the notion that the sitting president being indicted by the federal government, it just strikes me as utterly implausible. The notion of being indicted by the state court
It's possible if some judge let it go, but I think it will be struck down by the U.S. Supreme Court. I think someone mentioned earlier, can the president get a fair trial? Who's the jury of his peers, right? Can you imagine the voir dire, or as in Texas, voir dire, right? Interviewing jurors. So are you familiar with the president? Oh, really? You're not? Yeah, right. Right? Could you actually get a fair trial? Where would you have it? I guess in the District of Columbia, I suppose, right? Or maybe in New York, where the crimes occurred. Okay. But all this then just begs the next question: can the president give himself a pardon? At the outset, the pardon power only applies to federal crimes, right? The president cannot pardon a state law offense. He can only pardon a federal offense. There's nothing in the text of the Constitution saying the president can't pardon himself. You can argue as a structural matter, well, if I'm giving a gift from A to B, I can't give a gift to myself, so it makes no sense to pardon myself. Sure. But can a court even review a pardon, or is it final? And if the president pardons himself, and the court later finds, no, it's not valid, can they overturn the pardon? So these are very dangerous questions to get into. And you can't separate it from politics. I try hard in this class to separate law and politics, but it can't be. Because a lot of these claims are going to be motivated by politics, either against Paul Jones and Bill Clinton or against President Trump. And to what extent this does decrease with the energy and attention the president can devote to more important matters. You can't escape that question. Fortunately for all of you, I think we'll get some answers and probably even more debates in the upcoming years. Yeah, Kenny?
I have a question. It says here, and I understand why I have a follow-up, because he doesn't have to be charged or convicted to issue a pardon. So
Preemptive. You can do a preemptive pardon, yeah.
okay, so like the second you commit the crime, you can say, hey, just in case, I think you got it for this.
Right. So the most famous one was President Ford. After President Nixon resigned, President Ford gave a pardon to Nixon, very controversial, which says, I'm basically pardoning you for anything you've been charged with or you might be charged with. It's a blanket, right? Because Ford didn't know what kind of other crap Nixon had done. There might be some other stuff lingering they didn't even know about. Now, Ford likely lost re-election in large part because of that pardon. It was very unpopular. And Ford, to his dying day, said, I did the right thing by giving him this pardon. And the reason why is there was a case called Burdick, which says a person who accepts a pardon has accepted guilt. Didn't actually say that, but that's what Ford thought. He said by Nixon taking the pardon, he was accepting that he did something wrong. And for Ford, that was actually, that made it worthwhile. But the shorter answer is, you can give a prospective pardon. Recently, President Trump pardoned Arpaio, the sheriff from Arizona. He had been convicted, but not yet sentenced. Right? The judge convicted him, but they hadn't held a sentencing hearing yet. And a bunch of law professors followed up reasoning, no, you can't issue a pardon before the sentence has been issued, and the court just rejected it very quickly. Again, law professors don't lend your power. But to answer your question, Kenny, you can pardon prospectively. There's not a limit on it. And you had a follow-up?
No, I was saying, so, just if you get a whiff that they're investigating something, you can pardon, issue a pardon. You're good.
Okay. Right. So yeah, I mean, so one of the allegations against President Trump is he could shut down the entire investigation by pardoning his entire White House. Give like 30 pardons to everyone. That would end federal investigations. It would not end state investigations. That's why the state courts here are really important. You can't get away from that. Evan?
Do you know why the framers wrote into the Constitution this pardon power? Because it seems like a holdover from England of like the king's power. It just doesn't really align well with the rest of the Constitution.
Say it again?
Why did the framers allow this pardon power? It seems like a power a king has. You know, it just doesn't align well with like a democracy or, you know. It's like
It does.
extraordinary power.
It's a pardon power is an executive prerogative. It's an absolute. It's an absolute power. You're absolutely right, and it was one that was given to the president without much qualification. The limitation was viewed as one political, that giving this pardon is a public act. The person has to accept it, and people are going to know about it. And if he gives a bad pardon, he might be, he might pay the price for it. Nothing.
So with dual sovereignty, if he pardons Arpaio, that doesn't mean the federal government can come
State,
after
you
him?
mean?
Or state? Was he originally indicted under federal?
Arpaio was a charge under federal law.
So Arizona can then come after him for violation, and the president can't do it twice?
Nope.
And is any of his pardons up for judicial review at all? Could he just pardon Charlie Manson if he wanted to?
Isn't Manson dead?
Well, yeah.
I don't know if he can pardon a dead
Doesn't
person.
matter. Somebody of that nature where it's like,
Well, I don't know if Manson broke any federal laws, though, but he could, prospectively.
so it has to be a federal law.
Yes. JC? What?
I was just thinking back though, when the Constitution was written, they envisioned George Washington. I don't think they envisioned Donald Trump, President.
Right. I mean, that's true for a lot of things, right? If you imagine your executive as a guy like George Washington, who is a sterling character, you're not so worried about it. But the framers no doubt understood that a person of lesser character than Washington, which is not hard, right, would fall to the office.
I just wonder, when I was reading this, what's the context of the Cold War? Because we're engaged in this massive international act of showmanship of who we are. I mean, that really changed how the country expressed itself. I'm just wondering, the ability to hold the executive accountable to some extent, I mean, that comes into play, doesn't it?
Yeah. Right. Let me answer Denny's question. Nixon argued this, that all this Watergate stuff was weakening him on the world stage. Right. So imagine you're the premier of Russia, the Soviet Union, and you're trying to make a nuclear arms deal with Nixon. He's under investigation. Like, who is this guy? He might be out of office next month. I'm not going to make a deal. This is not a negligible fact, that when you weaken the president domestically, you weaken him abroad. And I've actually written about this, that one of the reasons why President Trump decided to fire James Comey, the FBI director, is he was screwing up his foreign relations, he said. There's this cloud of investigation. I can't go to other countries if I'm being investigated. This is actually, I think, a legitimate reason why the court may have not been so right in U.S. v. Nixon, that there were some national security implications here as well in those tapes, that there may have been. But they said there's no absolute privilege, it's not a qualified privilege.
I just want to ask your opinion. If he pardoned himself for, obstructing justice in the Supreme Court, how do you think the Supreme Court would hold?
If Trump pardoned himself,
And then they reviewed it in the Supreme Court, how do you
reviewed what, the issue of the pardon?
Yeah.
You can't review the issue of a pardon. That's not reviewable. It would be if someone, if in 2018 or 2020, whenever it is, another attorney general charged him with a crime for which he had pardoned himself. That's where it would come up, right? If some other AG tried to prosecute him for a federal offense, he would raise the pardon as a defense. Yeah.
I was going to say, in theory, though, if he were to pardon himself, you would pretty much lose all support.
It'd be devastating.
So, I mean, you might as well step down at that point anyway.
That's why the self-pardon, I think, is silly. It's not going to happen. It's a fantasy, right? But it's a fantastic exam question, but it's a fantasy. Denny.
I was thinking about Carter in this context, later on. The whole Iranian revolution and everything is a little off track, but still issues of executive power. I mean, there's definite evidence that Reagan is talking to the mullahs there, and that affects, the ability for President Carter at the time to make deals and such. So, I mean, like, we have a very squishy gray area when it comes to handing over power, who's coming into power, and what exactly the president has the ability to make deals with, right?
Yeah. There's no doubt when you hamper the president domestically with this litigation, it hampers him abroad. All right, I got a few minutes. Let me talk about the midterm for just a little bit, if I may. I haven't written it yet, so don't ask me the questions. I usually don't write till the very last minute, so I inadvertently don't give away the question. When you start thinking about the midterm, right, you need to start thinking very carefully about your cases, right? And the same way that I gave you these three statements at the beginning, you need to become fluent in cases. You need to know if there's a fact pattern about a subpoena in a criminal case. That means you're talking about U.S. v. Nixon, you're going to cite it. If you're talking about the president being sued, while he's in office, it's going to be Clinton versus Jones. But the way I'm going to ask you is not just one of these issues, it's going to be three of them at once, right? Where the president's being charged for a crime in state court while he's in office, right? Like that was my final exam question last year. And what you need to start thinking about is, this is similar to U.S. v. Nixon, different than Nixon v. Fitzgerald, and governed by Clinton v. Jones, right? Distinguishing how the fact pattern I'm giving you is similar to or different from will get you from a B to an A, right? And you need to cite the case and say, this is like U.S. v. Nixon because blah, 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 blah. And this is different than Nixon v. Fitzgerald because of X, Y, and Z, right? That's what makes the strong exam. Merely saying the president has absolute immunity from civil suits, period, that gets you maybe a B. But to push you over the top, you need to bring in the case of how this is similar to or different from. That's what you'll see. And if you take one of the old midterms beforehand and you compare it to the A+ answer, you'll see that's what the good papers try to do. Okay. All right, questions? What's in your mind? Completely open book won't help you. In fact, bringing it won't help you. I promise it won't. You have to be printed out. You can't be on your laptop. Make sure you print it. But a long outline will actually frustrate you because you're going to spend all this time flipping through pages and you're not going to have time to write. One other note, and I'll mention this briefly. Time is on your side. Why? I'm telling you exactly the format of the exam. There will be 5 questions in a fact pattern. If you have 90 minutes for 5 questions, you have to do some simple math, right? If it takes you 30 minutes to read the question, that means you have an hour left over. If you have an hour for 5 questions, it means 12 minutes per question. If you're tough on time, you get to question number 1, you get 12 minutes, stop, whether you're done or not. Question number 2, 12 minutes, stop. What you don't want to happen is give yourself 20 minutes for question number 1 and 5 minutes for question 5, because they're worth the same number of points. Same number of points, exact number of points. I can't tell you, the average for question number 1 is a lot higher than the average for question number 5. People run out of time, they start scrambling. Give yourself the same amount of time for each of the 5 questions. You'll be in a much stronger position. Cool. Half the final. That's everything's 50%. Yep, it's chopped right down the middle. I do exactly like that on purpose. You're welcome. All right. It's a preview. Other questions? All right, I'll see you all on Tuesday. Thank you very much.